you're not walking out of this courtroom today. Either you're going to be going to prison or either you're going to be going to inpatient treatment. You're going to get drug tested today. What are the results going to be?
They will come back positive.
Positive for what?
Methamphetamine. I just do it when I'm under stress. So I know I have a problem and I don't do it like around my children. I don't do it, every day. It's just, when I'm under stress and I was, really scared. And really under stress. So I don't do it when I go to work. I don't do it, every day, like I said.
I'm going to find her guilty, sentence her to...
All right, everyone. Today we've got a high-stakes courtroom showdown with a surprising twist. A mother facing serious drug trafficking charges is about to have her sentence decided by the judge. She's looking at up to 6 years in federal prison after authorities discovered a significant quantity of drugs linked to her case. What makes this hearing even more unusual is her statement to the judge. She claims that she only deals drugs sometimes. That's a striking claim, and while she presents it in a way that seems sincere, it's unlikely to carry much weight in federal court. The stakes are incredibly high, and the judge is focused on the facts and the law, not personal explanations that I want to hear from you. Do you think her statement could influence the outcome at all, or is the evidence too strong to be swayed? Drop your thoughts in the comments that if you enjoy courtroom drama and real-life legal cases like this, make sure to like and subscribe. I love reading your comments. And now let's dive into the hearing to see how the judge handles this case.
Today, according to the plea bargain agreement, she pled no contest to count 2 of the indictment. She applied for deferred adjudication. The state is proceeding only on count 2 according to the plea bargain agreement. Punishment is to be assessed at 6 years in the prison, and the state is silent on the defendant's application. The court requested that the defendant's criminal history be provided to the court. There were no objections to the court receiving that from the state. Is that correct?
Correct.
And any objections to the court reviewing that?
No, Judge, of course not.
All right. The state is silent. Is there anything you wish to say on behalf of your client?
Judge, of course, Ms. Torres is hoping you'll grant her application for deferred. She's in self-employed cleaning houses. She has several customers that rely on her. She has a few kids. She's just asking for the court to maybe direct her to some outpatient treatment because she believes she needs some help with this problem. And other than that, again, she's just hoping you'll grant her application.
All right. You want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right. You can lower your hand. State your name for the record.
Missy Ann Torres.
All right. So you're going to get drug tested today. What are the results going to be?
They will come back positive.
Positive for what?
Methamphetamine.
All right. So how often are you using meth?
I only do it when I'm under stress, and I did it because I could get denied for adjudication, so
I'm sorry, what?
I could get denied the application, so I just do it when I'm under stress. So I know I have a problem, and I don't do it like around my children. I don't do it, every day. It's just, when I'm under stress and I was, really scared, and really under stress. So I don't do it when I go to work. I don't do it, every day, like I said.
At this point, it's hard not to be skeptical about her claim of only using meth occasionally. Methamphetamine is widely known to be highly addictive, and casual or infrequent use is extremely uncommon. While we can't know her exact situation, statements like this naturally raise questions about credibility. If her claim isn't accurate, it could have serious implications for her children, who deserve a safe and stable environment. This adds another layer of concern for the court, as judges often consider the impact on dependents when making decisions in cases involving substance abuse. It's also possible that she's trying to appeal to the judge's leniency, which is something courts are trained to recognize. While every defendant is presumed innocent until proven otherwise, the court must weigh both the evidence and the potential risk to others, particularly children. What do you think? Could she genuinely be telling the truth? Or is this an attempt to minimize the seriousness of the charges? Drop your thoughts in the comments. And let's dive back into the hearing to see how the judge responds.
All right. So how many children do you have?
I have 3.
What are their ages?
11, 8, and 5.
And where are they now?
2 2 of them are with their dad and 1 is with my grandma.
All right. With your grandmother. So their great grandmother?
Yes.
All right. So, do you help take care of your children?
Yes.
How often?
I see them every other weekend, and I don't pay child support, but I pay them. My exes and I have my daughter. My daughter is with me.
No, you just said your daughter is with the
Yeah,
great
but
grandmother.
I live with my grandmother. This is it.
All right.
I help take care of her. She
All right.
helps me take care of her.
Okay. So one, I don't think it's appropriate for you to be cleaning houses
Okay.
because of the nature of this offense. And 2, I don't think it's appropriate for you right now to be taking care of your children.
That's why I'm asking for help, Your Honor.
I'm sorry, what?
That's why I was asking for help, Your Honor. That's why.
All right, your help is not going to be outpatient treatment if I grant this application for deferred adjudication. So you're going into custody today.
Okay.
All right. So it's just a matter of what I'm going to do with you. I will tell you the court's issue, and if you want to address this, I know the state is proceeding on count 2 of possession, but she had a lot of drugs with her.
No.
So I don't understand, if you're working homes, then why do you have a scale with you? Because that's, according to this, you had drugs, you had a scale in your purse, and there were baggies totaling 32.0 grams.
Well, Your Honor, I was a heavy user back then, and it was.
Oh, you're not, I tell you what, I don't think, and if I'm wrong, correct me, I don't think you were using 32 grams of meth.
It was only 28.
No, you have meth here for 4.964 grams, and you also have meth for 27.459 grams. And what you pled to in count 2 was a possession 4 to 200 grams. So this is not a possession 1 to 4. So we're talking about 27 grams. And according to the stipulations, that what was found in your bag, it says, I searched her bag, and inside a Paris Hilton makeup box were baggies, a scale, and crystal-like substance inside a cut, vacuum-sealed bag. That's from your Paris Hilton makeup bag.
At this point, the defendant's claims are starting to unravel. She's suggesting that her drug use is limited or only occasional. But the evidence in the case, baggies, scales, and quantities of hard drugs, paints a very different picture. Attempts to downplay involvement in court are rarely effective, especially when the facts are clear. The judge does a good job of addressing these inconsistencies directly, keeping the focus on the evidence rather than the defendant's explanations. It's also worth noting that any false statements made under oath can carry serious consequences, though proving intentional deception can be complicated. What's clear is that the most straightforward approach would be for the defendant to be fully honest and take responsibility for her actions. That allows the court to weigh the situation fairly and ensures that any decisions regarding sentencing or rehabilitation are based on accurate information.
So what I had, the meth it was double bagged in a sandwich bag. So yes, ma'am, I know it was 20, but it's because that was my personal. I didn't have any other. And last time I went, they tried to only give me which was 14 grams. So I had to.
No, what I'm telling you is, they said the baggie found in Robert's pocket tested positive for meth and had a field weight of 6.12 grams.
That wasn't mine.
No. I'm not saying that was yours. So the 6.12 grams that were found in his pocket, they're saying that was his. It was in his pocket. But the baggie, which was found in Missy's purse, tested positive for meth and had a field weight of 32.09 grams. Now, mind you, what they do in the field, I already know that testing drugs in the field are not legal for court. So I'm not considering the weight and what they said in the field. I'm considering what has been given to me for laboratory reports. So this was the professionals testing it, not a presumptive. And it says 27.459 grams was the net weight of the meth that you had in your Paris Hilton bag.
Yes, Your Honor. And I will say that I used to use a whole ounce within 2 to 3 days. So I was a heavy user, and like I said, they tried to give me half of that the last time, and right now it's going for $250. So if I'm paying $250, I wanted the whole thing. I wanted to make sure. I'm just being honest, and I'm sorry. Excuse me for being
No, I want you to be honest, and I want you to be transparent.
I'm sorry for being transparent, but it's something that I feel like I worked for my money, and I didn't want just to get gypped again. I can promise you I didn't sell anything. It was because I've been gypped many times. So I did get it. Now it was double bagged because I don't know, that's the way they gave it to me. I can't, and it is my mistake, and I'm taking full responsibility, but I wasn't selling drugs. I wouldn't, I have a job, and back then I was, a heavy user where I would just do it before work, after work, and I didn't have my children in my life. Now I do have my children back in my life, and I'm trying to be a good mom. So I thank you for, giving me an inpatient program.
Well, no. I'm not saying I'm going to give you inpatient. What I'm saying is that you're not walking out of this courtroom today. Either you're going to be going to prison, or either you're going to be going to inpatient treatment. So it's very important that you be 100% honest with me, because I'm telling you, the state proceeded on a possession, but the amount of drugs you had and the way they were packaged, that's concerning for the court. So you're saying that you just bought a bunch of meth and you were saving it up for use?
So I would use within 2 to 3 days. That was all my personal. Like I said, they tried to sell me half of that one time, and I went back to the same person, but I said, I'm going to wait myself to make sure I'm getting the right amount, because I'm an addict. I'm sorry, I am. And we're not.
So you travel with your own scale?
Well, at the time I did, because like I said, I've been gypped, and when you're an addict, that's all you think of, just how to get, make sure you're getting what you need.
Are you convinced by her explanation at all? Even for someone involved with controlled substances, carrying baggies and a scale is a serious issue. Simply possessing the drugs is enough to face legal consequences, but having tools associated with packaging or distribution significantly increases the severity of the charges in court. These items are strong evidence that the intent may have gone beyond personal use. When combined with the quantity of drugs found, it strongly supports potential trafficking or distribution charges. Courts typically view these factors as indicators of planning or intent, not just casual use. So the question becomes, is she misjudging the risk, or is this a strategy to minimize the appearance of involvement? Either way, the evidence is clear, and the judge is now preparing to issue the sentence. Let's dive back into the hearing to see how it unfolds.
I can see where I made my mistake, but I won't. I'm being honest with you. It was my skeleton measure, so my personal, that's it. And I don't know if Robert would tell you that was my personal as well. I don't want to call him or anything, you can if you want to, but he would tell you that's what I used to pick
I'm not going to be calling Robert, because Robert probably has a case of his own.
Right. But I'm saying Robert can tell you too, within 3 days, maybe 2 to 3 days, really, it would have been gone, and I would have been back doing it again. Now I don't. It was kind of like a stress thing. And
where did you get your drugs to use today before you came to court?
Just an old friend. I hadn't talked to him since, and it was on Saturday when I knew it was, coming, and I guess I felt,
Yes. Like, say something. I think the fact that she would actually go out and do the same drugs that she's about to get sentenced for in a couple of days, I think really speaks to the fact that she has a serious addiction problem that I think only rehab can treat. And if you decide that's ISF or SATF or SAFE, we understand that, but I think she really needs treatment.
Okay. All right. This is what the court is. Is there anything else for me to say? All right. This is what the court is going to do. I see that she hasn't been to prison before. I'm going to find her guilty, sentence her to 6 years in the prison, the therapeutic community. There's to be no contact with Robert Marble. Give her credit for any time served, and I'll retain jurisdiction.
I have to admit, 6 years is a significant sentence, and it raises some questions. Even though meth and other hard drugs are highly addictive and difficult to overcome, Is 6 years an appropriate amount of time for this case? On one hand, a sentence like this could provide her with the opportunity to reflect, seek treatment, and work toward sobriety. In that sense, it might be a turning point in her life that, on the other hand, there's a real human impact here. Her children will be growing up without her, which is a deeply challenging situation for any family. Balancing accountability with compassion is never easy, and this case highlights that struggle. I'm curious what you all think. Does the sentence feel fair, too harsh, or not harsh enough? Drop your thoughts in the comments, and let's dive back into the hearing to see how the judge finalizes the case.
Okay.
And you can explain to her what that means. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. I'll tell them. So here's the thing. When I say that I'm going to retain jurisdiction, what that means is they're going to take you to prison. If you're following the rules at the prison, if you're working on yourself, because they have programs at the prison, your attorney can file a motion. It's called shock probation. Back when I was growing up, they would have scared straight programs. So shock probation is sort of a scared straight program. So hopefully when you go to prison, you will clear your mind.
Yes.
The drug use or the addiction that you have, the craving that you have will be lifted. And if you are doing what you're supposed to do at the prison, if there are no bad reports at the prison, when your attorney comes back for a request for shock probation, I will strongly consider it. So while you're at the prison, you have 180 days. That's when he needs to bring it back before me before that time period. So you're going to do 6 months. And if you are doing well, if there are no write-ups against you, then the court will strongly consider giving you probation. You understand?
Yes, ma'am.
So, well, I mean, these are going to be choices that you make. It's going to be completely up to you whether or not I strongly consider giving you probation. Your attorney will explain it to you further, but any programs that they have at the prison, like the therapeutic community, to address your issue, you need to take it. I know they have parenting classes at the jail. I don't know how long the transfer will be, but you need to take advantage of that. When you see people come before me and they've gone to anger management class, they've done parenting classes, they've availed themselves of everything at the jail and everything at the prison, that is what you need to do. You need to immediately sign up for it. If for some reason there's overcrowding and they don't give it to you, it would be better for you to have signed up for it than to just throw up your hands and say, I'm not trying. Do you understand?
Yes.
And next time, if you have a case before any judge, don't use before coming to court. You understand? But I do appreciate your honesty, but you're going to have to get your life in order. Otherwise, children is going to be without their mom. You understand? All right. Good luck to you. You're welcome.
Thank you.
Now that the judge has issued the full sentence, it feels like the right call. Personally, I think Judge Boyd handled this case very well. She carefully weighed the evidence, the defendant's statements, and the circumstances, and the outcome seems fair. Even though the defendant was caught in lies and clearly made poor choices, the possibility of early release for good behavior after 6 months offers a chance to reflect and make positive changes. This case also highlights the challenges of addiction and decision-making. People can make harmful choices even when the consequences are clear, and the justice system has to balance accountability with opportunities for rehabilitation. Sometimes, tough love paired with time to reflect is what can truly lead to change. Hopefully, the defendant uses this time to turn things around, especially for the sake of her children. I'd love to hear your thoughts. Do you think the sentence was fair, too harsh, or just right? Drop your opinions in the comments. I love reading what you all think. If you enjoy content like this, make sure to like and subscribe, and let me know if there are any court cases or hearings you'd like me to cover next. Thanks so much for watching, and take care.